I am co-chair of the Manfred Lachs Moot committee, and I would like to read the summary of the problem. Welcome to this competition. I hope you understand my Mexican accent. First of all, I want to announce that the problem was written by Dr. Patricia Stern and Dr. Les Tanya. Dr. Les Tanya is my co-chair, and he sends wishes to all of you. The case is case concerning environmental contamination and harmful interference of space activities. Suris versus Nova Fredonia. Suris and Nova Fredonia, a special state-of-the-art sample return research facility in a remote area 200 kilometers from Resort City, a popular tourist destination in Suris on the shores of Cape Holiday, which is world famous for its lobsters. Nova Fredonia conducted the RS-1 mission to Mars to examine a previously discovered subsurface ice deposit and investigate whether the ice could be used in support of future manned missions. Suris conducted a sample return mission to Mars with probes to the planet as well as Deimos and Phobos. Pursuant to a memorandum of understanding, Suris agreed to purchase the use of the Nova Fredonia sample return facility. The MOU provided that the parties were to perform the agreement in accordance with a public advocacy organization incorporated in Nova Fredonia and with headquarters in Suris, participated in the mission by providing small self-contained canisters for the probes for Deimos and Phobos, containing sealed vials with samples of life forms from Earth to study what changes, if any, occur from exposure to the space environment. One vial contained a dormant blue halophilic bacteria. Messy, neither nor was granted any license or other form of authorization for the sample return mission from a Suris offshore launch platform. 6 months later, RS-1 was launched by Nova Fredonia. The Suris probe to Deimos developed technical problems and crashed into the ice deposit on Mars that RS-1 was sent to explore. While the fate of the Deimos probe was unknown, the RS-1 craft arrived and successfully landed at the ice deposit. RS-1 determined that the ice deposit was large enough to support the future mission. However, the ice contained traces of a bacteria virtually identical to the blue halophilic bacteria, except that it was purple and rendered the entire ice deposit unusable. RS-1 was unable to determine whether the bacteria was of terrestrial or Martian origin. Within months of the landing, the RS-1 spacecraft failed, and Nova Fredonia canceled the entire program. The other Suris probes returned samples of the Martian and Phobos material to Earth. The sample return facility discovered that the blue halophilic bacteria had been exposed to the environment of Phobos and was now purple. The bacteria replicated rapidly and, while not toxic itself, was attracted to the leaves of green plants, causing them to suffocate. The rapidly replicated bacteria threatened the physical structure of the sample return facility, but was neutralized by sodium chloride. As a precaution, Nova Fredonia evacuated the facility and sprayed a low concentration of sodium chloride around the perimeter. Suris declared a threat to public health and safety and ordered the evacuation of Resort City. Suris demanded the return of messy canister, but Nova Fredonia responded that the canister had been destroyed as a precautionary measure. The fumigation contained and neutralized the bacteria. However, natural weather patterns carried some of the sodium chloride into Cape Holiday, raising the level of salinity in the water to a level toxic to the lobsters. The lobster population was almost decimated, but after 3 years, approach pre-contamination rules. Zurich and Nova Fredonia have submitted this case to the International Court of Justice. We have here Judge Guery, Judge Koroma, and Judge Tomka. Thank you very much.
I now call on the plaintiff. What's your call of action?
Good afternoon, Your Excellencies. My name is Mrinalini Singh, and I'm agent for the applicant, the Republic of Zurich. My co-agent this afternoon is Ms. Navleen Kaur. With Your Excellency's permission, we will reserve 5 minutes for rebuttals and speak for 20 minutes each. I'm much obliged. Your Excellencies, this case concerns the apportionment of responsibility between two states when they jointly conduct a space activity. Here, the two states involved in that space activity are Zurich and Nova Fredonia, where Zurich was in charge of controlling a spacecraft which carried experiments to Mars and back to Earth again. And Nova Fredonia's role in the mission was to provide the expertise and research facilities where these experiments would be conducted once they returned to Earth. The applicant's position is that both parties in this dispute are responsible for the space mission at hand, for different stages and different parts of that space activity. And we ask this court to find that Nova Fredonia failed to carry out and to uphold its obligations under this joint space activity. This failure inflicted significant economic loss on two of Zurich's industries. In addition, instead of returning the canister which Zurich had entrusted to Nova Fredonia unilaterally destroyed that space object, as well as the experiment that it contained, which Zurich had carried for 13 months to deep space and back. We also ask this court to declare that although Zurich inadvertently did contaminate the environment of Mars, it took all reasonable measures to prevent this contamination and therefore complied with its international obligations under the Outer Space Treaty. This afternoon, I will make submissions on the extent of Nova Fredonia's responsibility for the activities of MESAI, which is the non-governmental entity that prepared and contributed the experiment relevant to these claims onto the applicant spacecraft. My co-agent, Ms. Kaur, will deal with Nova Fredonia's liability for the economic damage that Zurich suffered, as well as Nova Fredonia's breaches of its obligations under the return agreement. On the issue of Nova Fredonia's responsibility for this space activity, I have two submissions before this court today. First, that Nova Fredonia is responsible under Article 6 of the Outer Space Treaty for that part of the space activity which involved the studying of the MESAI experiment once it had returned from outer space. And second, that Nova Fredonia breached its obligations under Article 6 of the Outer Space Treaty by failing to authorize and supervise the study of this experiment in its research facility. My last submission for today, Your Excellencies, will be that Zurich complied with its international obligations when it conducted its exploration of Mars, although it inadvertently caused the contamination of Mars. Before moving into my first submission, the salient facts concerning the experiment relevant to these claims are: first, that the experiment involved carrying bacteria from Earth into deep space and back in order to determine if the outer space environment would have any effect on Earth's bacteria. And second, that this experiment was carried on Zurus's spacecraft, which was at the time already going into deep space, to conduct a separate set of experiments independently planned and executed by Zurus. Moving on to my first issue, that Nova Fredonia is responsible for Messi's activities under Article 6 of the Outer Space Treaty. And under this submission, the applicant's position is that in a joint space activity where there are two spacefaring nations involved, both nations must be internationally responsible for that space activity. Zurus accepts that it has international responsibility for the part of the experiment which was in its sole control, which is when the spacecraft traveled to outer space and back. However, we ask this court to find that Nova Fredonia is also internationally responsible for that stage of the experiment where this experiment was studied on its territory, because it was an experiment studied on its territory and by its national. Your Excellencies, under Article 6 of the Outer Space Treaty, states are internationally responsible for their national activities in outer space. And the applicant submits that a national activity should be any activity that is conducted under a state's jurisdiction. Both the Outer Space Treaty as well as the Travaux Preparatoires to the treaty are silent on what exactly a national activity is. And therefore, the applicant relies on the writings of Professor Binching, whose opinion this court can consider under Article 38(1)(d) of the ICJ statute. And Professor Binching states that a national activity is any activity under that state's jurisdiction, because these are the activities that are within its legal power and competence to control. And that this jurisdiction can be territorial. Nova Fredonia is internationally responsible for that part of Messi's activities where the experiment was studied, because at this crucial stage of the space activity, Nova Fredonia had territorial jurisdiction over that experiment by its national. First, Your Excellencies, on Nova Fredonia's territorial jurisdiction over the study of the experiments in its research facility. This experiment was planned, sealed, tested, and subsequently studied, all in the respondent state, Your Excellency. It is important to stress that the entire rationale for Nova Fredonia's involvement was precisely because it had the expertise and research facilities in order to study the experiment, which Zurus did not have. And this is precisely why Nova Fredonia was asked to become involved in this research, in this experiment. The applicant does recognize that Nova Fredonia initially rejected to be a part of this space mission. And this is in paragraph 8 of the counterclaim.
Recognize that she did not have the expertise to launch the space flight, but you did undertake to carry out such a difficult mission. Why should the respondent be held liable?
Excellency, we do acknowledge that we did not have the expertise to study the experiments while they were on Earth. And this is precisely why, before proceeding with the space activity, we requested that Nova Fredonia come on board to provide that very expertise to ensure that the experiments could be studied in a facility that was adequate. Your Excellency, under the Outer Space Treaty, the Outer Space regime seeks to provide a balance between ensuring that a space activity is safe, but also encouraging a state to conduct those space activities. It requires a state to take measures to ensure that in conducting that activity, it takes appropriate measures to ensure that it is safe and makes its best efforts of the Outer Space Treaty. Yes, Your Excellency. And in this case, it is precisely because the respondent state came on board as the state which should have provided that expertise that Nova Fredonia needs to be responsible for the failure to supervise the experiment while it was in its research facility. To clarify, Your Excellencies, for whatever damage was caused in outer space while the applicant was in control. It was Zurus's responsibility to ensure that, to take precautions for the space activity. But while the experiments were in Nova Fredonia's specially constructed research facility, they were the state that was supposed to provide that expertise. And when they failed to do so, and failed to take quarantined measures to ensure that the experiments were safe, that is what we asked this court to make Nova Fredonia internationally responsible for, and not for the entire mission as a whole. Your Excellency.
Yes. Tomka.
My question, what was the cause of the emergency, minor emergency causing that facility? Was there a failure of the facility or another different reason? Container.
Your Excellency, the reason for the evacuation of both the respondent's own facility as well as the applicant's resort city was because of Nova Fredonia's failure to contain the Messi canister's bacteria while it was in its research facility. And this is stated in the compromise itself. The compromise states that when the Messi canister was opened in Nova Fredonia's research facility, that the bacteria in the canister was replicating and threatening the structure of the entire research facility. And because Nova Fredonia was concerned that it was going to threaten the whole physical structure of the facility, that it announced that it required an evacuation, and based on this alarming announcement, they evacuated that facility, and Zurus took steps to ensure its safety as well. Your Excellency.
They should have done nothing?
No, Your Excellency. Your Excellency, we do understand that Nova Fredonia did have to take steps to deal with the scientific experiment which is in its research facility. However, our position is that first, this experiment should never even have reached the stage where the entire research facility needed to be evacuated in the first place. And this was because Nova Fredonia should have taken adequate quarantine measures to protect this experiment. And this is a basic requirement when conducting biological studies. And second, Your Excellency.
Why did the British take measures in Torikanian incident? You recall the Torikanian incident?
I apologize, Your Excellency. I cannot
Please
assist you.
proceed. Please proceed.
Thank you, Your
That's
Excellency.
the very you discussed that.
Thank you, Your Excellency. Having dealt with Nova Fredonia's responsibility for the experiment that was conducted in its research facility, this takes me to my second submission, that Nova Fredonia breached its obligations to authorize and adequately supervise the study of the experiment, and it was the appropriate state to do so under Article 6 of the Outer Space Treaty. Under Article 6 of the Outer Space Treaty, the activities of a non-governmental entity shall require authorization and supervision by the appropriate state. And the applicant submits that where two states are involved in the activity, both of those states will be the appropriate state to supervise different parts of the activity depending on their capabilities as well as the reason for their involvement in that space mission. And while Zurus accepts that Zurus would be the appropriate state to ensure that its spacecraft was adequate, we ask this court to declare that Nova Fredonia was the appropriate state to authorize and supervise the part of the space activity where the experiment was studied in its facility, and that it breached its obligations because it failed to take basic measures such as quarantining the experiment before it was opened.
But Council, Messi was not a governmental organization.
Yes, Your Excellency, MESI was a non-governmental entity in this case. And under Article 6 of the Outer Space Treaty, the activity, if I can take Your Excellencies to the exact text of Article 6 of the Outer Space Treaty, the second sentence states that the activity...
Okay, please proceed.
I'm much obliged, Your Excellency. Here, our argument is first that Nova Fredonia was the appropriate state to authorize and supervise, and second, that it breached its obligations by failing to do so. First, Nova Fredonia is the appropriate state because it was best placed to ensure that the study of this, both the Outer Space Treaty and its travaux preparatoires, are silent on what exactly, or who exactly rather, the appropriate state is under the Outer Space Treaty. However, Professor G. Silverstraw, who wrote extensively on space activities under the former USSR, states that the appropriate state has to be the state which is best placed to carry out the authorization and supervision. Your Excellency, we acknowledge that other jurists have different suggestions, sometimes suggesting that the launching state or the registry state is the appropriate state. We acknowledge this. However, the common thread in all of these jurists' analysis is that the premise is that it is the state best placed with the highest chance of securing the fulfillment of its responsibility that has to be the appropriate state. And in this case, Your Excellency, Nova Fredonia was best placed to ensure that quarantine measures or accurate measures were taken in its own constructed research facility.
I may ask. My understanding is that Nova Fredonia, so the director of Nova Fredonia Space Agency refused the offer. So, what was then the involvement of Nova Fredonia in the project? Because my understanding, you would like to divide the responsibility for different parts of the space activity and plan, that Nova Fredonia is responsible because it provides a state-of-the-art facility for evaluating the results of the space research. So is the basis for your claim international space law, or rather contractual obligation under the Memorandum of Understanding? Because these facilities were provided on the basis of a Memorandum of Understanding, which you claim is legally binding and not take any issue with this qualification.
Your Excellency, our claim is under international space law, even though the agreement between the two states was a contractual one. Under the outer space regime, this regime specifically requires that all activities entail international responsibility, and this is of course slightly different from the position under general international law. However, Your Excellencies, during the negotiations of the Outer Space Treaty, this is precisely the bargain that was struck. Because the former USSR was concerned about allowing merely contractual obligations to govern space activities because of the ultra-hazardous nature of that activity. It required that all activities entailed international responsibility precisely because of the ultra-hazardous nature of the space activity. And here, Your Excellencies, Nova Fredonia did participate. We do understand that they initially rejected to be part of the space mission. However, on the factual matrix, they subsequently did come on board for that experiment. They provided state-of-the-art research facilities. They provided the expertise, and they were also to benefit from the study of these experiments because their scientists were also able to gain the benefit of the experiments in their territory. And for this reason, we proceed under international space law. Your Excellency, I see that my time is almost elapsed. May I summarize the submission and briefly summarize my last submission?
Yeah.
Thank you, Your Excellencies. Your Excellency, the apportionment of responsibility here is consistent with how space activities are currently conducted in the world today. Right now, Russia is conducting the Phobos Grunt mission, which is almost identical to Zurus's mission. In that mission, Your Excellencies, Russia is conducting tests over the entire spacecraft because it acknowledges that that spacecraft and the mission is its responsibility. However, the entity that is providing the experiment, which is identical to the MESI experiment, the Planetary Society in that case, that entity acknowledges that it is its responsibility to ensure that the experiment is prepared and tested as well as studied safely, Your Excellency, because of the different expertise between the scientists as well as the Russians who are carrying the spacecraft into outer space. Your Excellencies, I see that my time is up.
Make your submission.
I'm much about Your Excellency. And therefore, it is consistent with current space activities for this court to determine that Nova Fredonia is the appropriate state to supervise the study of this experiment. It failed to do so, Your Excellency. The obligation to ensure that the experiment is conducted safely requires at the very basic a quarantine measure. However, Your Excellency, none of these measures were taken. Thank you, Your Excellency.
Good afternoon, Your Excellencies. My name is Navleen, and I'm co-agent for the Applicant, the Republic of Firas. I'll be addressing two issues today. The first is regarding Nova Fredonia's liability for Firas' significant economic damage arising from the evacuation of Resort City and the drastic reduction in Firas' lobster harvest. And the second issue is regarding Nova Fredonia's violation of its treaty obligation under the Return Agreement. Our submission to the first issue is that Nova Fredonia is liable in international law for the significant economic damage that it caused to Firas, arising from the evacuation of Resort City and the drastic reduction in Firas' lobster harvest. And second, Nova Fredonia violated Article 5 of the Return Agreement in failing to return the Mesa canister to Firas. Before I go into my first submission, the relevant facts here are that Firas was forced to evacuate its popular tourist destination for weeks because Nova Fredonia had failed to ensure the safe handling of the Mesa canister carrying this bacteria upon its return from outer space. Having failed, Your Excellencies, to safely contain this bacteria upon its return from outer space, Nova Fredonia then neglected to involve the applicant state with regard to any decision-making as to the steps that it could take to contain this bacteria. Even though, Your Excellencies, this was a joint space activity. Instead, despite Nova Fredonia's knowledge that the bacteria would potentially take 3 months before it would escape into the facility, Nova Fredonia proceeded to fumigate its surrounding areas with enough sodium chloride to raise the salinity of Firas' Cape Holiday to a level that was toxic to Firas' lobsters. And Your Excellencies, it's important to stress that these lobsters contribute significantly to Firas' fishing industry.
So you don't think a preventive approach was appropriate?
Your Excellency, here it's important to stress that while we accept that Nova Fredonia's use of sodium chloride was a precautionary measure in the circumstances, it's important to stress that Nova Fredonia knew that it would take at least 3 months before the bacteria would have escaped into the atmosphere. As such, it had ample opportunity to involve Firas to minimize the risk of transboundary harm, which did unfortunately occur here, Your Excellency. That being the background, we submit that the respondent is liable on 2 grounds. First, with respect to the evacuation of Resort City, Nova Fredonia is liable under Article 2 of the Liability Convention. And second, with respect to Firas' drastic reduction in its lobster harvest, Nova Fredonia is liable in general international law.
Was that loss foreseeable?
Yes, Your Excellency, it's our submission that, if I may clarify, is Your Excellency referring to the loss of the lobster harvest? Yes, Your Excellency, in that case, Nova Fredonia had sprayed sodium chloride into the air of its surrounding areas with crop dusters, and this was dragged by natural runoff into Firas' Cape Holiday, which affected the composition of Cape Holiday, and Cape Holiday is world famous for its lobster harvest, Your Excellency.
Yes, Tomka.
You said that Nova Fredonia is liable under Article 2
Yes, Your Excellency.
of the Convention on International Liability. So, the question is, which object has caused that damage? Because the liability convention
that the space object here is the Messi canister containing the bacteria that returned from outer space, Your Excellency. This has not been disputed by the respondent. Would Your Excellency like me to explain why it's a space object under Article 1D of the Liability Convention?
Otherwise, I'm going to ask this question.
Certainly, Your Excellency. For Article 1D of the Liability Convention states that the term space object includes component parts of a space object as well as its launch vehicle and parts thereof. This is a non-exhaustive description, Your Excellencies. As such, this court can consider the writings of eminent jurists under Article 28(1)D of the Statute of the ICJ. Professor Binching has stated that a space object is any object that's intended for use in outer space. And this is in line with the functional approach that was adopted during the drafting of the Liability Convention. Yes, sir.
If this was this canister, which in your argument is a space object of Nova Fredonia, what is the basis for you claiming the return of that canister to you?
Your Excellency, it's important to stress here that eminent jurists such as Professor Bruce Howitz has stated that with regard to its space object in Article 2 of the Liability Convention, a literal interpretation cannot be taken. It does not refer to the ownership of the space object, Your Excellency. And here it's our position that Zurich is the owner of the space object. However, Nova Fredonia and Zurich are joint launching states of this space object that caused the damage. As such, we recognize that this court will be hesitant to impose victim-oriented absolute liability on one joint launching state. However, we submit that Article 5 of the Liability Convention deals with the situation of joint launchings and it states that where two or more launching states launch a space object, they shall be jointly and severally liable. In that case, Your Excellencies, Article 5 envisions a claim by a third-party victim state, Your Excellency, who would then be able to claim from either of these launching states for the damage that was caused. And if the damage was caused on the surface of the Earth, then the victim state could claim for absolute liability from either of these launching states. And Your Excellencies, here, however, our situation is slightly different. And it is a joint launching state that has the victim state here. Professor Gaurav has stated that with regard to apportionment of liability as between joint launching states, the apportionment should be conducted on the basis of fault. And fault has been defined to mean the failure to exercise reasonable degree of prudence in the circumstances, Your Excellency. And as my co-agent has alluded to earlier, Nova Fredonia failed to ensure the safe handling of this canisters upon its return from outer space. As such, it is the state that's wholly at fault and therefore wholly liable under Article 2 of the Liability Convention. Your Excellencies, the critical issues here are first, whether damage to resorptivity is compensable damage under the Liability Convention, and second, whether the damage was caused by the Messi canister. Addressing the first issue, it is submitted that the loss of use in resorptivity constitutes damage to property as under Article 1A of the Liability Convention. The Tribunal Preparatory to the Liability Convention is silent on the definition of damage to property. However, Article 31, subsection 3B of the Vienna Convention on the Law of Treaties allows for the subsequent practice in the application of the treaty, such as the Canadian claim in Clause 954. There, Your Excellencies, Clause 954 in that claim, Canada had described property damage as its property being rendered unfit for human occupation as a result of Soviet Union's nuclear weapons. As a result of Soviet Union's satellite debris. And while Canada could show no visible changes to the environment, she suffered damage because her property was rendered less suitable for human use. And further, Your Excellencies, this court has also accepted such a definition of damage to property in the case of nuclear tests, Australia and France, where Judge De Castro's analysis of the case recognized that Australia had suffered property damage because its property could no longer be used as a result of contamination by France's nuclear weapon testing. Yes, sir.
Perhaps a difference between the view of the court and the institution and the opinion of the judge sitting on the bench. It seems that you described views of the court, but in that case the court has
Professor Foster, who state that damage to property has occurred when it is rendered less suitable for those human purposes for which it was originally valued. And here, Your Excellency, Resort City suffered a loss of use as a result of Nova Fredonia's inadequate containment of the Mersai canister entrusted to its care. Addressing now the second issue of causation, we submit that the damage to Resort City was a proximate cause of Nova Fredonia's release of the bacteria. The Travaux Preparatoires to the Liability Convention does not only state that there must be a causal link between the accident and the damage caused. As the Lachs specialist does not provide a definitive test, Your Excellencies, we can look to general international law.
I mean, Your
Yes, Your Excellency.
in my understanding, the cause of the damage was the use of sodium chloride, table salt.
Your Excellency, to be clear,
So it was not the bacteria that was the cause of the damage to your fishing industry or to tourist industry,
Your Excellency,
but the chemicals used by Nova Fredonia to contain bacteria.
Your Excellency, let me clarify my argument here. Our claim with regard to the evacuation of Resort City is that damage was caused to Resort City as a result of Nova Fredonia's inadequate containment of the space object. However, with regard to Nova Fredonia's use of sodium chloride that resulted in the ensuing drastic reduction in Zurich's lobsters, our claim in that case is under general international law. And here, Your Excellencies, the loss of utility in Resort City was a proximate cause, as it was a natural and foreseeable consequence of Nova Fredonia's failure to contain the bacteria. It's important to stress here that the information regarding the threat that the bacteria posed was in exclusive control of the respondent state. Zurich could only assess the risk that was present based on Nova Fredonia's alarming announcements that it was evacuating its own research facility and fumigating its surrounding areas. Zurich acted on the side of caution and evacuated Resort City for 3 weeks, Your Excellency, and it suffered a loss of revenue as a result. Therefore, Your Excellencies, it's our position that Nova Fredonia is absolutely liable under Article 2 of the Liability Convention for Zurich's economic damage arising from the evacuation of Resort City.
How do you reconcile your claims? Earlier, minutes ago, you said that the claims on the basis of general international law
Your
for the
Excellency,
use of sodium chloride.
Your Excellency,
And now you claim under the Outer Space Convention.
Your Excellency,
The legal regime is quite different.
Yes, Your Excellency, I understand. However, to be clear with regard to Zurich's position, our first claim with respect to the evacuation of Resort City is brought under Article 2 of the Liability Convention. However, our second claim with regard to Zurich's drastic reduction in its lobster harvest is brought under general international law, which I will now address, Your Excellency. It is submitted that Nova Fredonia breached its international obligation to prevent transboundary harm to Zurich under the Trail-Smelter Principle. The Trail-Smelter Principle stipulates that states are obliged to prevent harm caused by their nationals to other states even where the harmful activity in itself is lawful, and this principle has been affirmed by this court in Cronau. We accept here, Your Excellencies, that Nova Fredonia's use of sodium chloride was a precautionary measure. However, it was still obliged in international law to respect the interests of other states. In the late Cronau arbitration involving the proposed diversion of an international river by an upstream state, the arbitral tribunal had affirmed that a state has an obligation not to exercise its rights to the extent of ignoring the rights of other states. And in that case, Your Excellencies, France had a duty to consult with Spain as its proposal to divert the waters would affect the composition of the downstream state and affect Spanish interests. And here, Your Excellency, clarification 4 to the compromise states that determinations regarding the fumigation with sodium chloride was solely made by Nova Fredonian authorities. This is despite the fact that Nova Fredonia had knowledge that it would take at least 3 months before the bacteria would be released into the atmosphere. Therefore, Your Excellency, there was ample time to consult with Zurich, its neighboring coastal state, before undertaking such a measure. And it was also foreseeable that sodium chloride sprayed into the air by Nova Fredonia with crop dusters would reach Cape Holiday, its neighboring water source. And in paragraph 23 of the compromise, Your Excellency, it's an agreed fact that this sodium chloride was carried by natural runoff drastic reduction in Zurich's losses. Consequently, Your Excellencies, Zurich lost a significant part of its national revenue as these losses form a major part of Zurich's fishing waters. And therefore, it's our submission that Nova Fredonia is liable in international law for the transboundary harm that it caused to Zurich and must compensate Zurich for the ensuing national revenue loss.
So they did not know that the harm was going to be caused to the lobster harvest.
Yes, Your Excellency, we accept that the respondent did not deliberately seek to harm these lobsters. However, its use of sodium chloride was severe enough to affect the composition of its neighboring coastal state waters, Your Excellency. And in fact, given that Nova Fredonia did not need to take immediate action with regard to the bacteria, having known that it would take 3 months before it would escape into the atmosphere, Nova Fredonia could have consulted with Zurich and should have consulted with Zurich, as this was a joint space mission, and it would have then been able to minimize the transboundary harm that unfortunately occurred.
Your claim compensation for the environment is based on very international law. Isn't there a circumstance precluding the wrong purpose, like necessity that Nova Fredonia found itself in the state and it was required to act in order to contain the spreading of bacteria?
Your Excellency, it's our position that the defense of necessity is not available to the respondent state with regard to its use of sodium chloride in the surrounding areas. This is because there's no grave and imminent peril to its state, as having known that it would take at least 3 months before the bacteria would escape into the atmosphere, Your Excellency. As such, we submit that the defense of necessity is not applicable here. Moving on to my second submission, Your Excellency. Nova Fredonia violated Article 5 of the Return Agreement. It states that upon request, space objects shall be returned to its launching authority. We recognize here that Nova Fredonia failed to submit to this request because it had already been destroyed. However, this action was in violation of Article 5 of the Return Agreement, as there is an implied obligation to safekeep the space object while awaiting a request by the launching authority. And here, Your Excellency, this obligation to safekeep, it has the support of learned jurist Professor Jason Tuliana, who has stated this in the 3rd volume on the Manual of Space Law. He cites the example of New Zealand as acting consistently with its obligation under Article 5 by safekeeping the space object while awaiting a formal request by its launching authority. And in the interim, New Zealand did not take any unilateral action. We acknowledge that this particular authority may not be sound when dealing with hazardous material. However, Article 5.4 entitles the state to only take effective steps to eliminate any possible danger of harm. And, Your Excellencies, it's respectfully submitted that here Article 5.4 cannot apply. This is because our position is that the respondent should never have reached a stage which necessitated the neutralization of this bacteria with the use of sodium chloride. Without prejudice to this position, Your Excellency, we recognize that they have already used the sodium chloride and to nullify this threat posed by the bacteria. As such, it could not then take further step of unilaterally destroying the canister, Your Excellency, without any consultation with Zurich. And its actions resulted in Zurich being deprived of any opportunity to scientific research on this space mission, Your Excellencies. In conclusion, Your Excellencies, the respondent's failure to comply with its obligations in this joint space mission and unilateral actions led to economically devastating effects on the applicant that could and should have been prevented. If Your Excellencies have no further questions, that will conclude my submission.
Why do you think the respondent chose to destroy the canister?
Your Excellency,
How you cannot enter their mind? What do you think is mistake?
Your Excellency, here, with regard to Article 5 of the Return Agreement, having already taken the step to neutralize this bacteria, Nova Fredonia had no basis in international law to unilaterally destroy the canister, Your Excellency. As such, we do not understand its actions in unilaterally destroying the canister when the harm posed by the bacteria had already been eliminated through its use of sodium chloride.
So that is the basis of your cause of action.
Yes, Your Excellency, Article 5 of the Return Agreement is our basis. Thank you, Your Excellency.
My name is Rossi, and along with my co-agent, Ms. Tanya Cronau, I represent the respondent in this case, Commonwealth of Nova Fredonia. Both my co-agent and I will be speaking for 20 minutes, and we would like to reserve 5 minutes for Sir Rebuttal at this time. Thank you. Today I will show that Xeris, and not Nova Fredonia, is responsible for the Messiah experiment and the damages resulting therefrom on Mars and Ares 1 specifically. Ms. Cronau will then show that Xeris is responsible for the contamination of Earth and the cost incurred by Nova Fredonia to contain such contamination. Your Excellencies, this is a case about Xeris, and only Xeris, planning a mission to Mars and trying to avoid responsibility after the mission has resulted in damage to Mars and to Nova Fredonia specifically. It may be persuasive of Xeris to isolate facts and law and to show this court only a fragmented picture of the case at issue, but I will show the whole picture, and how Xeris is responsible and not Nova Fredonia for the Messiah experiments and all the damage resulting therefrom. Xeris is responsible for the Messiah experiment, which constituted providing canisters of samples of Earth life to be flown into outer space on the Xeris mission for 3 reasons. First, Xeris alone is a launching state. The Messiah experiments are national activities of Xeris, and Xeris, and not Nova Fredonia, is the appropriate state party under Article 6 of the Outer Space Treaty. First, Xeris alone is a launching state. Not only do opposing agents continually admit that Xeris is a launching state, but Xeris also is the only state which fits the strict definitions provided in Article 1C of the Liability Convention and 1A of the Registration Convention of a launching state. Relevant provisions of those articles show that Xeris is a launching state in that it launched space objects, or the Messiah canisters at issue here. Such objects will launch from its offshore platform, its own facility, and the launch of these objects were procured by Xeris through its contractual relationship with the Rebuttals rocket. Article 7 of the Outer Space Treaty, without using the specific term launching state, also says that any state which fits these definitions is liable for the damage caused by launched objects. Because liable for these objects under this article and under Articles 2 and 3 of the Liability Convention, Xeris is responsible for the launched objects, the Messiah canisters here. Xeris in its claims would have this court hold Nova Fredonia responsible for the Messiah canisters as a launching state, but it cannot be denied from evidence and law that Xeris is the only launching state. Opposing agents' memorials suggest that Nova Fredonia, in licensing Rebuttals to provide private launching services, makes it a launching state. But the strict definitions of the Liability Convention do not contemplate licensing as a definition of launching state, nor this kind of connection to classify a state as a launching state, especially for a mission for which it had nothing to do. It also suggests that registering the launch and the payload make it responsible. And it claims that only a launching state can register under the Registration Convention, but that language is not found in the Registration Convention. And in fact, under Article 4(1)A of the Registration Convention, it can be interpreted that there can be differences in the state of registry and the state of launching, since registration can include the names of launching states. Because Xeris alone, and with no connection or encouragement from Nova Fredonia, is the launching state of the Messiah canisters and the mission at issue, Xeris is responsible for all damage resulting from the Messiah canisters. Your Excellencies, not only is Xeris the launching state of the mission at issue and of the canisters themselves, but the Messiah experiments were national activities of Xeris. Article 6 of the Outer Space Treaty says that states shall bear international responsibility for their activities in outer space, whether or not conducted by governmental agencies or non-governmental entities. This should be interpreted as imputing direct responsibility over non-governmental entities involved in national space activities, or else a third party could be used by a state to shield itself from liability. This is a national activity for which Xeris is directly responsible for, because Xeris had control of the whole mission which it conducted and the Messiah experiment from beginning to end. It was set up by the Xeris government, and it undertook facilitating the entire launch and the experiments which it coordinated to have place upon its mission. Then Xeris publicly announced that Messiah and others were involved in its mission, showing to the international space community at large that it was undertaking the responsibility for the experiments which were being concluded. Thirdly, the Messiah experiments, the canisters themselves, were in fact sent to the Zurich Space Affairs Ministry and controlled by the Zurich government. A national activity has to be one in which the government controls the activity, just as Zurich's government has controlled the Messiah experiment. Article 3 of the Outer Space Treaty also points to support towards finding that space activities must be conducted in accordance with international law. This court, in the Koroma case, stood for the proposition that states are accountable for the activities within their territory over which they have control. Within the Zurich territory, this mission was planned, and within the Zurich territory, the canisters were sent. And it was within the Zurich territory that Zurich had control over whether or not these canisters were fit for spaceflight, and it alone could have decided whether or not these canisters were sent into outer space, ensuring that they were not faulty nor leaking. Also, Articles 8 and Article 6 of the International Law Commission's Articles of the State's Responsibility for International Wrongful Acts suggest that states are responsible for private entities under its control. Therefore, Messiah, being under Zurich's control, is the responsibility as a national activity of Zurich. Zurich, in its claims, would have to support Messiah as a national activity of Nova Fredonia, suggesting that Nova Fredonia could have asserted varying jurisdictional controls over Messiah. While it is technically true that the Messiah canisters were created within Nova Fredonia territory, and Nova Fredonia could have asserted territorial jurisdiction in the beginning of the experiments, it is practically irrelevant to say that Nova Fredonia should be responsible for activities for which it had nothing to do, nor the compromise indicate that it even knew that these activities were being conducted within its territory. Also, quasi-territorial jurisdiction that opposing agents refer to in their memorials is only over the door-to-door rocket, the launch vehicle, and not over the Messiah canisters, as the registration which Nova Fredonia undertook was only of that rocket and was not specifically in relation to the Messiah canisters. While it may be also true that Messiah could be considered a national of Nova Fredonia because it is incorporated within Nova Fredonia, personal jurisdiction is not only given lesser weight in determining a national activity, but it also still does not mean that Nova Fredonia had anything to do with the Messiah activities. Because Zurich, as a nation, through its government, controlled all aspects of this mission, it is a national activity of Zurich, and not of Nova Fredonia. Because Zurich is both the launching state and the appropriate state party, it automatically follows that and that the activities were national activities of Zurich, it automatically follows that Zurich alone is the appropriate state party to have authorized and continually supervised the activities of Messiah under the second sentence of Article 6 of the Outer Space Treaty. To hold otherwise would appear illogical that any other state than the one with all of the control of the mission were to be obliged to oversee the non-governmental entity's activities. Zurich alone should have authorized the canisters in their construction and supervised their creation, despite wherever they were being made, because it was ultimately going to be incorporated upon the Zurich mission. Zurich, in encouraging the participation of Messiah, knew what kinds of objects it was sending into outer space, and so Zurich alone could have regulated the Messiah activities and approved the experiment for inclusion in its own space mission, not Nova Fredonia. Even if this court is not persuaded by my previous arguments that Zurich alone is the launching state, or that this is a national activity of Zurich, Article 6 of the Outer Space Treaty, and that second sentence, which requires authorization and supervision, is found as the appropriate state party under Article 6 of the Outer Space Treaty. First, it allowed Messiah to join a mission which was Zurich's mission, the sample return spacecraft mission. And again, it was in the best position to know the involvement in the mission that Messiah was conducting. Also, it had jurisdictional control over the canisters at the most important moment, pre-launch, when it was sent to the Zurich Space Agency, because it could decide what to do with these canisters cannot be sent into outer space. In addition to being the state in the best position to assert control, Xeris also has a genuine connection with the non-governmental entity. And the genuine connection test is set out by this court in the Barcelona traction case, in which this court balances one state's interests against another's. In the strictest sense, it may be a national of Nova Fredonia because it is incorporated there. However, for purposes of this mission, Mesai had a genuine connection with Xeris. First, it was headquartered in Xeris. Your Excellency, Xeris has also had several successful missions, and just because a few missions have gone awry does not mean that Xeris can step away from its responsibilities. Your Excellency, because this particular mission they were, in fact, disregarding their responsibilities. Because Xeris has disregarded its responsibilities concerning the Mesai canisters, it has contravened international law on contaminating Mars. In contravention of Article 9 of the Outer Space Treaty and Article 7 of the Moon Treaty.
Yeah. Second, for the state government, there's been established that they are responsible. What will be your claim? Will be remedy to the contamination? Are you seeking some remedy?
Yes, Your
Or
Excellency.
just a declaratory judgment from this court?
There's both a declaratory judgment that this court hold that Xeris is responsible for contaminating Mars to show the space community that ensuring our space resources are essential for future endeavors. That directly flows into the damages which Nova Fredonia can obtain from this court because of the direct damage to the Guery's spacecraft on Mars. The damages that would be given to Nova Fredonia are under Article 12 of the Liability Convention. Article 12 stands for the proposition that restitution damages are given to a state in order for the state, in fact, Right. In order that the state be put back in the position to which it was before the damage occurred, and this is echoed throughout international law generally. For the foregoing reasons, we ask this court to hold Xeris responsible for the Mesai experiments and the damage to Xeris. No, Your Excellency, but our spacecraft and our mission as a whole has been completely wiped out by the contamination on Mars. So no further questions? Thank you, Your Excellencies.
Thank you, Mr. President, Your Excellencies. May it please the court, my name is Tanya, Cronau, and along with my co-agent, Ms. Rossi, I represent the respondent, the Commonwealth of Nova Fredonia. Your Excellencies, this case is about accountability, holding a state accountable for the fact that it contaminated Earth by not allowing it to shift responsibility for the state that intervened and reduced its Earth contamination. Today, I will show you that first, Xeris violated international law when it failed to prevent the contamination of Earth. Also, that Xeris is liable for the costs associated with the containment and fumigation of the bacteria within the Nova Fredonian sample return facility. That also, Nova Fredonia is not liable for the effects of the contamination, of the containment and fumigation, namely the costs associated with the diminution of the lobster harvest and the evacuation of Resort City. Last, I will show you that Nova Fredonia did not violate any provision of international law when it did not return the canisters to Xeris. First, Your Excellencies, Xeris violated international law when it failed to take appropriate measures to prevent Earth's contamination. Article 9 of the Outer Space Treaty provides that state parties to the treaty shall conduct activities in outer space so as to avoid adverse changes in the Earth's environment, and further states that where appropriate, states shall adopt appropriate measures for this purpose. Article 9 does not enumerate what steps may be appropriate in certain circumstances. However, we ask this court to hold that in this mission, Xeris should have abided by the Coast Guard Planetary Protection Policy. This policy does not have its separate binding force of law because it has not been codified in treaty form, and as such is not a treaty recognized by the Vienna Convention on Treaties. However, Xeris had the requisite knowledge in that it was a member of the Coast Guard. It knew the procedures existed, knew what they entailed, and knew that they were promulgated by COSPAR for the specific purpose of ensuring that its member states were in compliance with their duties under Article 9 of the Outer Space Treaty. There are 3 provisions of COSPAR that are relevant to this mission. First, it's important to note that this mission is specifically provided for by COSPAR and that it is a Category 5 Restricted Earth Return Mission. The first provision, Your Excellencies, is that unless a space object is sanitized by approved sanitization procedures, the state must ensure that the canister containing the samples is fail-safe and that this fail-safe nature of the canister is throughout the entire mission fail-safe. The second relevant provision, Your Excellencies, is that no uncontained hardware which contacts Mars directly or indirectly should be allowed to return to Earth. The last provision is that member states must continually reevaluate and reapprove the mission at various stages, most importantly, before it leaves the Martian atmosphere, and also before it is committed to Earth's re-entry. So essentially, Your Excellencies, to comply with Article 9, Zurich should have ensured that the sample return canisters were fail-safe throughout the entire mission, and that any uncontained hardware, namely the sample return canisters with the leaking vials, were not allowed to be returned to Earth. Circumstantial evidence does show that Zurich did not follow these procedures because the leaking canisters were exposed to Martian environment and the parasitic extraterrestrial bacteria was allowed to re-enter Earth's atmosphere. Admittedly, there is no direct evidence in the compromise to indicate what pre-launch testing Zurich undertook and whether it was in compliance with COSPAR. However, this court should shift the burden of proof to Zurich to prove that it did follow these procedures, rather than requiring Nova Fredonia to prove that it did not.
Why we should shift the burden?
Your Excellency, this court should follow the principle followed in the Corfu Channel case, and also most recently, the case concerning Amadou Sadio Diallo. In 1947, in the Corfu Channel case, Great Britain provided this court with enough circumstantial evidence to create a presumption that Albania knew of certain activities happening within its borders. Unfortunately, Albania possessed the rest of the information, which would have proved this knowledge directly. Because of this exclusive control over the remaining direct evidence, this court allowed Great Britain's burden of proof to be met by circumstantial evidence. Similarly, in the case concerning Amadou Sadio Diallo, the Republic of Guinea alleged that the Democratic Republic of the Congo did not afford a citizen appropriate procedures relating to that citizen's imprisonment and extradition. This court noted that when a state has a duty to follow certain procedures and has or should be expected to have documentation that it did follow these procedures, the burden is properly shifted to that party, instead of requiring the pleading party to prove what this court termed the non-existence of a fact. Zurich has or should have documentation that it followed COSPAR procedures, especially considering that COSPAR itself requires members to keep logs of any pre-launch testing. Additionally, this burden-shifting standard is also seen in customary state practice. In American law, for example, under the doctrine of res judicata, by the European Group on Tort Law, which is comprised of member representatives of over 18 different countries, and is also followed by the Tort Law of the People's Republic of China. Nova Fredonia asked this court to hold that Nova Fredonia has met its burden of proof by circumstantial evidence showing that Zurich failed to adequately prevent contamination of Earth in accordance with its duty under Article 9. Your Excellencies, Zurich is also liable for the cost associated with the containment and fumigation of the bacteria. Article 7 of the Outer Space Treaty indicates that a state shall be liable if it launches a space object when that space object causes damage on Earth or in outer space. Article 2 of the Liability Convention later classified this liability as absolute when the damage occurs on Earth. Absolute liability does not require the pleading party to prove fault, just duty, breach, and harm caused. The duty here was the duty to prevent Earth's contamination under Article 9, which Zurich breached, This breach caused parasitic bacteria to be introduced into Earth's environment and contamination of the sample return facility. As prominent space law scholar Kaur notes in his article, International Liability for Damages Caused by Space Object, a party can recover damages for harm resulting from contamination, as this is property damage contemplated by the Liability Convention. Xeris attempts to relieve itself of this liability for the contamination of the sample return facility based on the statements that Nova Fredonia allegedly allowed the bacteria to escape into the Earth's atmosphere. However, this is a misrepresentation of the compromise. And also, Agent for Xeris implicitly admits this did not happen by admitting that the contamination was preventative and that it prevented the bacteria from leaking into the atmosphere. Your Excellency, as Slovakia noted in the Gapsikovo-Nagamaros case, a state has a duty to mitigate its damages under international law. This is exactly what Nova Fredonia did by reasonably fumigating within and without the sample return facility.
As you perhaps know, although the court said that it was duty to mitigate, does not work that the circumstances prevailing wrongfulness can be taken into account when calculating the damages. And the contribution of state is fair to take these measures when it claims compensation.
Yes, Your Excellency. However, the situation of Slovakia and Nova Fredonia is different in this regard, and that Nova Fredonia's fumigation is not wrongful and is not in violation of international law. The fumigation was in fact reasonable, considering the facts and circumstances known to the scientists. The blue bacteria had mutated into a form of purple parasitic bacteria. Not only did the color change, the basic molecular structure of the bacteria was altered markedly. The bacteria that was introduced into the outer space environment was halophilic in nature, in that it thrived in saline environments. The bacteria that returned was actually halophobic in nature, which is evidenced by the fact that it was neutralized by a low concentration of sodium chloride, which is, as His Excellency Tomka pointed out, commonly referred to as table salt. Additionally, the characteristics of the bacteria changed. The blue bacteria was and had been dormant for thousands of years. The purple bacteria, on the other hand, rapidly replicated and also had a tendency to be attracted to chlorophyll and suffocate the plant containing the chlorophyll. Maybe most importantly, Your Excellencies, because of the fact that this bacteria was extraterrestrial, this means that no organism on Earth, plant, human, or animal, had any sort of natural immunity to it. So it was essential that Nova Fredonia prevented the bacteria from escaping to Earth, which it did by fumigating with a low concentration of table salt.
Yes, Judge Shui.
Counsel, can I ask a question? Even under that circumstances, do you think Nova Fredonia has the obligation to inform these to any?
Yes, Your Excellency. Yes, Your Excellency. And as the company indicates, Nova Fredonia notified the international space community of the plans to fumigate. Moreover, there is no evidence to prove that Xeris was unaware of this, as the compromise indicates that Xeris representatives were present in the sample return facility when the canisters were retrieved. Your Excellencies, because this fumigation was reasonable and not wrongful, Nova Fredonia should not be held liable for the effects of contamination of the containment and fumigation, namely the diminution of the lobster harvest in Cape Holiday and the evacuation of Resort City. The diminution of the lobster harvest in Cape Holiday.
What is the authority for that submission?
The submission.
That you had to use sodium chloride to fumigate, first of all, and at the same time, your fear that the canister might prove deleterious, you have to destroy. What is the legal authority?
The action you have taken.
The legal authority, Your Excellencies, is the duty to mitigate. Nova Fredonia had a duty to mitigate the contamination. And additionally, as is recognized by the UN Articles of Environmental...
If you action to mitigate that would be toward the reduction of the damage.
Yes, Your
But
Excellency.
your decision to destroy is different. What is the reasonable legal basis in your view? Why did you have to destroy?
This press
Oh, the
necessity
destruction of the
of-
canister?
Yeah, that's
Okay, my mistake. I
No, no.
apologize.
Why?
The destruction of the canisters was a reasonable preventative measure and was not a separate violation of international law as the agent for Zurich proposes. The agent for Zurich has admitted that its sole basis of its claim rests on the rescue and return agreement. However, we ask this court to hold that the rescue and return agreement as a whole, not just Article 5, does not apply to this case. The preamble of the rescue and return agreement indicates that its purpose is to help assist states when, due to accident or distress, astronauts or space objects are found in the outside of the territory of the launching authority. This is echoed in Article 5 relating to the return of space object, where a careful reading shows that the article uses the terms found and discovered the space object outside the territory of the launching authority. This is not the situation that happened here. The canisters were purposely, intentionally brought into Nova Fredonia territory per the agreement between Zurich and Nova Fredonia. This is outside of the scope of what the rescue and return agreement contemplates. So there is no other basis under international law that Nova Fredonia violated any sort of obligation by the destruction of the canisters. Zurich does not bring to this court any sort of proprietary interest in the canisters. In fact, by its argument that Nova Fredonia was responsible for the canisters, it necessarily admits that it had no proprietary interest in the canisters. Because of this, we ask this court to hold that Nova Fredonia did not violate any international law when it failed to return the canisters to Zurich. As to the lobster harvest and the diminution of in the evacuation of Resort City, Your Excellencies. The diminution of the lobster harvest was a direct result of Nova Fredonia's lawful and reasonable mitigation efforts. Therefore, there's no basis to request damages for this action because it was not, as Agent for Zurich argues, any sort of transboundary harm prohibited by international law. Additionally, Agent for Zurich argues that Nova Fredonia has a duty to compensate for the evacuation of Resort City somehow under Article 2 of the Liability Convention. However, as His Excellency Tomka stated, Article 2 rests upon the presumption that a space object caused the damage. However, as Agent for Zurich admits, the fumigation caused Zurich to evacuate. Moreover, this evacuation was not reasonable, considering the fact that the compromise indicates that representatives for Zurich were present at the time of retrieving the canisters, and there is no reason to assume that Zurich did not know of the facts surrounding the situation. Even if this court was to find, however, that the evacuation was reasonable, this does not change the outcome of the case. We do not. Your Excellency, Nova Fredonia provided to the international space community its plans to fumigate. It did not provide
the community, but the other party, the dispute has been properly notified and informed.
Your Excellency, we ask this court to hold that the notification to the international space community was sufficient. First, Zurich representatives were present at the Singh return facility, so there's no reason to assume they did not know. Second, the fact that Nova Fredonia notified the international space community as a whole actually furthers the goals of the Outer Space Treaty in that it was notifying everyone of the situation, not simply singling out Zurich. Because the notification was reasonable, and whether or not the evacuation was reasonable, we ask this court to not hold that Zurich violated any provision of international law by evacuating, but simply that Nova Fredonia is not responsible for the effects of it. In conclusion, Your Excellencies, We respectfully request that this court hold Zurich in violation of international law by failing to prevent the contamination of Earth.
You said no, that Sidonia is not responsible for the evacuation.
Yes, Your Excellency.
To say, okay, you may be responsible, but your action precluded wrongfulness. Because you're saying that you're not responsible for so, and at the same time you're arguing that the action taken was not.
Your Excellency, we argue that although the fumigation may have been a cause of the evacuation, it is not responsible for the effects because the act was not wrongful. Yes, Your Excellency. We ask this court to hold that the fumigation is not wrongful. And as such, that Zurich is responsible for the economic effects of it and not Nova Fredonia. Is there any further questions?
Thank you very much.
Your Excellency, I have 3 rebuttals to make today. First, that Zurich did fulfill its international responsibilities under Article 9 of the Outer Space Treaty, and therefore did not violate the Outer Space Treaty, even though Mars was unfortunately contaminated. Your Excellency, the respondent's position is that Zurich violated international law when it contaminated Mars, and that Zurich should have taken fail-safe or indestructible space objects into outer space. However, Your Excellencies, Article 9 of the Outer Space Treaty does not create strict liability, but rather requires states to take measures to make its best efforts to prevent the damage that might be caused. And on our fact, Your Excellency, Zurich did make the effort to ensure that its spacecraft would be safe while in outer space. 2 crucial facts, Your Excellency. First, clarification 35 to our compromise states that Zurich conducted a pre-launch test of its entire spacecraft, including the missile canisters, before it went into outer space. And second, Your Excellency, in paragraph 14 of the compromise, it states that before the canisters were incorporated into Zurich's spacecraft, they were tested by MESAI before they were even sent onto the spacecraft, Your Excellency. Therefore, Zurich has taken measures to ensure that its spacecraft is adequate before going into outer space. We do acknowledge that it is unfortunate that the contamination of Mars occurred, but we fulfilled our obligations under Article 9 to take steps to prevent that damage, and these were best efforts made by Zurich. Your Excellency.
Yeah, where do you read that in Article 9?
Your Excellency, Article 9 states that states must take appropriate measures to prevent the harmful contamination. Your Excellency, it does not state that on strict liability or once there is contamination.
Okay, so that's how you interpret appropriate as not tantamounting to strict.
Your Excellency, this is also shown during the negotiations to the outer
Honestly, I don't want to know because it's not in the
yes,
article.
Yes, Your Excellency, we're relying on states' obligation to take appropriate measures to prevent. Your Excellency.
Yes, Judge Shui.
In your first round, argue strongly that whatever Messi did it was done in the territory of the respondent. Now you say you have taken every possible preventive measures. How do you make your argument ground sound?
Yes, Your Excellency. As we submitted, both states have a responsibility in this case. And Zurich's responsibility was to ensure that the spacecraft as a whole was adequate before it went into outer space. And our submission here is that Zurich did take those steps through its pre-launch test and to ensure that when the experiment returned from outer space and then moved onto its territory, that Nova Fredonia should have ensured that it was safe at that point in time, Your Excellency. And this is why both states have responsibility in this mission. And our argument is that we have fulfilled the responsibilities by taking appropriate steps to prevent the contamination of mass. But that Nova Fredonia, when the canister was in its facility, did not take quarantine measures to prevent this from happening.
Then actually is a very important element when you talk about responsibility. That is, what is really crucial activity? Is territory or is activity? So what are activities that can internationally govern that group? The key link.
Your Excellency, the exact law that governs this is Article 6 of the Outer Space Treaty, which doesn't require actual control over the activity for a state to be held responsible. And this is the lex specialis of space law that is different from the position under general international law. Your Excellency, I see that my time is up.
We have a meeting. We have a further question.
Therefore, in this case, under general international law, the applicant state would have to prove that there was actual and effective control over that activity. But this is not the position under space law, because states specifically wanted all space activities to attach international responsibility because of the ultra-hazardous nature of the activity. And Your Excellency, there is responsibility if it is under your territorial jurisdiction, and this was earlier the definition provided by Professor Binchek. And so even if it is on their territory, Your Excellency, that entails state responsibility rather than the actual control which we would be required under general international law. If I may.
In relation to the argument that you state all fulfill the obligations in supervising the mission, which nevertheless resulted in pollution of the environment on Mars. Leaving that aside, Nova Fredonia is claiming this was to own space mission as the IS-1 spacecraft was able to return. Do we have taken responsibility and liability?
No, Your Excellency, because in order to claim for damage caused to a spacecraft in outer space, the respondent would have to prove under Article 3 of the Liability Convention that there was a fault on the part of the applicant state. And this is stated in Article 3 of the Liability Convention, which creates four. Your Excellency, the applicant state can only be made to bear liability if it falls on the part of the applicant that we would not have to compensate them for.
If you have read notice, I have never referred to applicant and respondent.
Right.
And I think that both parties have their own claims, and they have agreed to come before us and to adjudicate on these claims. So they have asked for compensation, and the damage goes to them, and I understand.
Your Excellency, are there further issues that I can address?
Yes, your final submission.
Yes, Your Excellency. Finally, that Firas is not liable for the containment of the bacteria on Nova Fredonia's territory, because this was specifically what Nova Fredonia was responsible for. Under the MOU between the two state parties, Your Excellency, it provided.
That's enough. I want to go to the final submission.
Yes, Your Excellency.
Treaty, even though Mars is contaminated, Article 9 says that states shall take preventative measures. Firas points out that they conducted pre-launch testing, but does not show how these pre-launch testing, or how this pre-launch testing fulfilled the duties required by a mission with such inherent risk that Coast Guard has specifically contemplated. It also says that these canisters were tested by MESI, but Firas should have been there at this testing as the appropriate state party to ensure that this testing was appropriate, because MESI itself, as pointed out in clarification 3, does not have any of its own scientific expertise. and still we have Mars being contaminated and damaged. Also, we are not saying that Mesai shouldn't be attributed to a state, just that it should be attributed to the appropriate state, and in this case that is Xeris. Xeris points out that the Ares 1 damage must have come under fault liability under Article 3 of the Liability Convention, which is true. But Xeris does not show how it was not at fault for the damage on Mars, only makes a conclusory statement that it was not. In fact, had Xeris... Yes, Your Excellency. In this case, fault is not taking the appropriate measures for the situation, or the due care the situation requires. Here, as we argued earlier, Xeris has not followed COSPAR regulations. Had Xeris followed COSPAR regulations, even if the Deimos probe had crashed, the canister which leaked the bacteria and contaminated Mars would have been in a failed-safe canister and would not have leaked nor cracked upon crashing into the Martian environment. For these reasons, we ask that this court not find for Xeris' rebuttal. If there are no further questions.
Yes, just a little bit, could you educate me on Article 9? Because it contained a mandatory obligation, because if I understood your last submission was that Article 9 requires mandatory preventive measures.
Yes, Your Excellency, the language is that a state shall take appropriate measures in conducting and using in the exploration of outer space. Those measures are not expounded upon in Article 9, and that is why this court looks to COSPAR. Yes, Your Excellency. Thank you, Your Excellencies.
Listen to very interesting submissions. The court will now recess for its decision to be reached. And I'll ask agents of both parties to hold themselves and dispose of the court should we require for assistance. But before delivering the verdict, court would like to congratulate both plaintiffs on their outstanding performance. We have had the level of play has been extremely high, and in some instances, not necessarily all, even higher than what we experienced in the real court, in the international court. So it's a tribute to your outstanding performance that you could have mastered not only space law but international law. Your familiarity with the jurisprudence of the court has been just, we've been very much impressed, all three of you. And did you discover one thing, that all the agents and co-agents are women? Yes, we would like to congratulate you on this outstanding performance. And in this case, it's not token. I think your presentation shows that your depth and breadth of international law and outer space law it's just not, as I say, just not a question of technicism, but it shows that you earn your right to represent your different states before the court. So again, I would like to congratulate you. I'm sure you'll be an inspiration to the other teams in the future. But it's not only your team this morning. In fact, throughout the whole competition, because we also decided to judge the morning's competition, the African sector, and most of the agents were also women. So that's how it shows how well the women are doing as far as space law is concerned. And I think we are coming to the more agreeable part of space law, because now space law is being so privatized, and I think that there's a lot of material benefit. For in the earlier period, it was more idealism, talking about the common heritage of mankind, space law being the province of mankind. But now, I think with space tourism and so on and so forth, and then there is every reason to combine both idealism and, if you have to earn your meal ticket, I show there is a place in outer space law. So, I know expectations are high. We don't want to keep you waiting for too long, but as I said, we've been very much impressed by the performance, and in this sort of game, at the end of the day, one team has to decide, has to prevail, and we're very much, the court reached a unanimous decision and found in favor of the respondent. And I congratulate you. And now, for me, to hand this over to the president.
Koroma, and congratulations first of all to all the lady students. I have noted that also, and that is interesting indeed. I cannot agree more with the honorable judges that the students have performed remarkably well, and that is not only the case of the World Finals, but equally so of the African introductory round of this competition. And I would like to make a formal announcement here that the Board of Directors of the Institute has approved during its meeting on Monday the creation of an official African regional round of the competition. Which means that from next year there's no more free tickets to the finals. So you will still have to write excellent memorials, but this will no longer be the case that the team with the highest grades for the memorials goes directly to the finals. We will also have more headaches because we have to organize 2 semi-finals, but we will see that when we get there in Naples. For the time being, I would like to put on record our extremely deep appreciation to the World Court judges. This is really a very, very distinctive feature of our Manfred Lachs Moot Court competition this year in its 20th year. And Judge Koroma especially has been, I think you have been to 70 of them. I have been counting. And Judge Tomka has had several as well and has been extremely helpful in convincing his colleagues that they should really join this exciting competition. Up to even 2 days before I left for Cape Town, he managed to convince Judge Hanqin, whom we are very, very happy to welcome here for the first time. For the first time, ladies. From China, and I hope that you will be back and that you will all be back. And without further ado, I would like to give you a very heavy token of These are the proceedings of the Institute. They are getting bigger and bigger. We have to work on not saying so much about space law.
We're going to start it, and we better prepare for the next round.
Stand here. Can you hand me my I am. We are going to call the teams up here because we have, as you see, some awards and a trophy, which you see here as well. The trophy this year is in a different format. Some of you may have heard that last year we have lost part of the original Lachs trophy, which had been traveling around the world for many years, and we have been lucky to convince Judge Tomka, or Judge Tomka has accepted, has proposed actually, to put the original trophy after restoration at the International Court of Justice in The Hague. So it has found a permanent home there, and we're extremely honored by that. And in the meantime, we have produced this replica of the trophy, which will come with us to the Congress every year for the winning team to hold and to take pictures, but then we will bring it back home and it will reduce the stress of the missing trophy parts, hopefully. I am going to first call here all the teams that participated in the African introductory round. We had 3 teams that participated in this competition, which took place yesterday. The preliminaries and the finals took place this morning. Some of you attended this. 3 universities took place. They came from Kenya, Nigeria, and South Africa. And I'm going to start with the Best Memorial Award of the African Introductory Round. I have to take my paper here. The winner of, and now I'm not sure which university it was. Martha, I need your help. Which country is giving this? Nigeria is the winner of the Best Memorial Award in the African Introductory Round. Could you please come forward? And we have Christopher Akintunde Iseolua. Who's that? Congratulations. Toby Adebowale. Sorry if I don't pronounce it right. And Victoria Ojo. Congratulations. Hold on, there will be much more. I am going to the best oralist of the African introductory round, and this is a young lady from South Africa by the name of Serena Joy Kalpskog. Where are you? Then I would like to call up the university University from Kenya, which was the second runner-up in the African introductory round. Are they here? We have Vivian Mutoni, that must be you. Michael Martini, that's you. And Claudius Mogunde. Where's Claudius? You will bring it for him. And we have an award for you, plaque, which says second runner-up in the African introductory round. This is unique because there won't be any more. Place in the African introductory round, and that is the University of Pretoria in South Africa. Serena Joy Kalfskop and Petronel Kruger. Round is from Nigeria, and I'm calling again the team from Nigeria to come to the floor. Christopher, I said the name, and the coach is here as well. And we have a plate which I hand to you. Tell you also that the judges told me that they were extremely impressed with the quality of the African round. So Europe, Asia, and North America, you better beware because you are in a tough time. We are now going to move to the World Finals, and we're again going to start with the Best Memorials Award, and that is the University of Singapore. May I please ask you to come here? Navleen Kaur, Mrinalini Singh, and Firas Mohamed Alsuwaigh.
Thank you.
Congratulations.
Thank you. Thank you very much.
No. I'm sorry.
That's right.
Navleen, you can come back because you also get the Best Oralist Award.
Thank you very much.
We now go to the ranking in the World Finals, and we will start with this, with the team from Europe from the University of St. Petersburg. May I ask you to come here? There are Maria Kiskachi and Maxime Ousini. Well done, congratulations. And also who performed extremely well here today was the University from Singapore. Can I ask you again to we're going to have a lot of overweight back here. Firas. pleasant thing for me to do is to call the winning team here, the State University of Florida in the United States, as the winner of the World Finals 2011 in this 20th Manfred Lachs Moot competition. Their names: Lynn, Guery, Tanya, Cronau, and Rossi. And the Lila Award for the winning team. Also, maybe Marta and Timmy, you can hand out the books to the other teams. The trophy is going to come to the dinner, and that's where you can show it up from the pictures. We would like to ask all the students to come here and to have some pictures with the judges. There's one last thing that I would like to do. Since this is the 20th competition, I offered a little present to the Institute, and that is a pin of the Manfred Lachs Moot Court competition with the new logo of the competition. And I would like to offer the 3 judges this pin as a token of our appreciation. I forgot to say that. So, photo time.